Can the activity of cutting and grooving of aluminum composite panels amount to manufacture so as to attract central excise duty? We have a very important ruling of the Supreme Court on this very issue. The assessee in this case is a construction contractor who, amongst other things, was affixing these aluminum composite panels or ACPs on the exterior facades of buildings. For this purpose, he was importing pre-coated ACPs in standard sizes and thereafter cutting them into rectangular or square shapes as per the customer's requirement, depending on the facades or the buildings being constructed. The CESTAT had ruled in favor of the assessee, and the revenue went in appeal before the Karnataka High Court. The issue of maintainability was raised by the assessee before the High Court. However, leaving the question of maintainability unanswered, the High Court ruled in favor of the revenue and the demands were restored. The assessee then went into appeal before the Supreme Court, and the Supreme Court has held in favor of the assessee, giving detailed findings on both maintainability and the issue on merits. As regards maintainability, the Supreme Court here held that the issue of excisability is directly and proximately connected to the rate of duty for the purpose of assessment. The appeal in such case lies before the Supreme Court under Section 35L 1B of the Central Excise Act and not before the High Court under Section 35G. As for the merits, that is, the issue whether cutting and grooving of ACPs amounts to manufacture, the Supreme Court applied the twofold test of emergence of distinct commercial goods and marketability, both of which have to be independently satisfied. It was held that what emerges from the process is still an ACP. The essential characteristics of the commodity remains entirely unchanged, and there is no emergence of a new distinct commercial product. It was also noted that the burden of establishing marketability lies with the revenue, which had produced no evidence to show that there was an emergence of a new product as known to the market. This judgment comes as a major relief to those taxpayers who have often faced excise duty demands on processes undertaken solely to provide functional utility to the product. The Supreme Court has categorically held that making superficial changes in order to facilitate the use of goods without altering the fundamental properties thereof does not bring into existence a distinct commodity. This does not pass the transformation test of manufacture, and therefore excise duty cannot be attracted. Thank you.